Welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and we are going to take a deep dive with Todd Duell's legal record. Let me make some clarifications real quick before I dive into all this. Hang on one second. Lit up like a Christmas tree. All right. This is in no way a hit piece on Todd Duell or any of his claims that he has made in the prior videos, social media, whatever. Okay. I've watched some of his videos, I've read some of his stuff, not all of it. I understand the complexity theory of what he's trying to accomplish. Absolutely. I've been on this journey a long goddamn time. I've been through a gazillion gurus. Thankfully, I've never paid a shit ton of money for an incomplete lesson, a lesson learned. But as always, I reached out to Todd today. I sent him a nice text. I posted it in my Telegram. So if you're not part of my Telegram, that's where I play. I don't play over in Twitter. I don't play over in X, Facebook occasionally. But I use Telegram because I can upload my videos. Doesn't matter how long the video is. And as fast as it'll upload and fast it'll download, you can watch it. It's the backbone of my whole platform. And I use it because I can move 4 gigabytes of information instantaneously, or I can even go store it over in Telegram. You can create your own personal file, your own personal database. Most people don't know that, but that's why I use Telegram. So if you really want to know what the hell's going on, just go over to Telegram. I post stuff over there constantly, all day. I don't really play around in it. I just post stuff. I'll read stuff and comment every now and then, but that's about it. So I did reach out to Todd. I'll read you what I sent him. I restarted everything, so everything's got to reload. There we go. I'm just going to read it to you guys. Hi, Todd. My name is Floyd Pleasant Tarvin IV, creator/host of the Fearless Floyd Show. I've been watching your interviews, and your premise piqued my curiosities. Like any good researcher, I went straight to the record. Yours, Pacer and Dawson. Don't take this personally, but all of your interviews were softballs. My audience would like to hear from, quote, the horse's mouth, close quote, meaning you, and someone questioning you with meaning and depth, and not a cheerleader, promoter, and such. I'm doing a show tonight at 7 p.m. Central Standard Time in which I will inquire into each of your legal filings in Pacer and Dawson, which I cannot open in Dawson. I'll get to that in a minute, and review your legal acumen. I'm multi-published and have filed just about every legal vehicle known seeking relief in various aspects of my then circumstances. In such, I am cordially and graciously reaching out to invite you to appear as a guest on my show either tonight or another date. I've been doing this since 2013. I've been investigated by the FBI and USPS inspector twice, Secret Service and IRS in my endeavors, and still here and free. I know who all the players are in this community, who's legit, who's scamming, and who's a legal moron. Plenty of these. You are more than welcome to search my full name for my bona fides. I'm generally free every day for a conversation, a show, or to share knowledge and experiences. You can call, text, or email me at my cell phone number, 9 to 9 p.m. Central Standard Time, or the Fearless Floyd Show at yahoo.com and the fearlessfloydshow.com. I seriously hope and desire you entertain my invitation to appear or at least have a conversation. Happy holidays and all the best, Floyd. And he did reply. So I gotta open up an app so I can read the reply. I can read it off my phone. I really don't want to show his phone number, even though some of you may have it. This was his reply. I only work with IRS CID, Criminal Investigations Division, and other professionals that have been in court for 30 plus years winning on the accounting. For example, one of my partners has discharged over $500 million in tax issues with the IRS. He has never lost. 2 weeks ago, that was the first text. Second text, he hit me back 5 minutes later. 2 weeks ago, we also beat the IRS in U.S. tax court for a client. They walked away from $450,000, I guess, in debt. I immediately replied, is that a yes or no? And I waited for a reply for an hour. That was at 3:22 when I sent it. 4:24, after no reply, I texted him back, I'm not disputing your success. Never have. And I don't know. All I can do is go look at the record, his record, what he's done for him, by him, I guess. I wouldn't assume that he would have an attorney representing him to the court, right? That just doesn't make sense. So again, I invited him on the show. I read you his answer. And take that however you want. I'm not going to even make a comment on it, except he's not here. I invited him. I read you the invitation. I hope I did it graciously and kindly enough with blunt force trauma without beating around the bush and telling him, hey, I want to get on your side and, be a pom-pom cheerleader for you. No, I'm searching for the truth. And believe me when I tell you this, I have a lot of people behind me that they have money. I have money. I'm not stupid with my money. I'm not silly with my money. I'm very frugal with my money. I want my money to make me money. That's what it's all about. That's what I'm all about right now is, get rid of my trash and rejuvenate it with things that are going to make money. So my money's making money for me. I'm not working for money. Money's working for me. Get it? So I've always said I'm more than willing to pay for an education for somebody to get me to whatever the promised land looks like. And I have a bunch of people who will take my word in good faith that, hey, if this is the path, come on. Hey, it costs X amount of dollars. You good with that? Yeah, come on. Because they're going to take my word that it's the real deal. Because I'm searching for the truth, whatever the truth looks like. However far it is to go, however hard it is to work. Okay? I've always been straight up with you guys. I've been fair and square in all my dealings with you, searching for the truth, searching for the answer, right? And that what we're all looking for is freedom, sovereignty, self-governance. I've always said the IRS is your friend. I told you the other day when I originally stumbled into this whole private process stuff, after analyzing all the legal mumbo jumbo, that it made sense to me that the relief would be in the United States tax court, either that or the Federal Court of Claims, because I really didn't have access to that database of case law or enough information to be able to pursue that avenue I was kind of stuck in the rut of, a writ writer in prison chasing writ of habeas corpuses, appeals, actual innocence claims, parole packages, CPS, you know, child support payments, just you name it, wills, probate. I did everything. So I tell everybody, if you want to know anything about me, just Google my full name, search me, go on Westlaw, LexisNexis, and you'll see my litigation. You can go to the Travis County clerk, you can go to the Walker County clerk, Harris County clerk, First Court of Appeals, 14th Court of Appeals, Texas Court of Criminal Appeals, Texas Supreme Court, PACER. You can find all my stuff. It's not like I'm hard to find. So I've been in the trenches. I fought the fight, and I've done what I need to do. And when I can review somebody's record, I can obviously tell if they know what the hell they're talking about. That's why I made the reference that there's a bunch of legal morons running around out here who are freaking very dangerous. Do not for a minute think that these people are, tame. They are dangerous because they have enough legal knowledge to do the wrong thing because they don't know what they're doing. They just have legal knowledge. You have to be able to apply it. That's why it's called a practice, because they are constantly practicing law, practicing medicine. You get it now? So again, this isn't a hit piece. Listen, Todd, if you're watching, because I told you I was going to do the show, I would love to hear from you. I'd love to interview you. I'd love to press you more on some of the issues that you brought up and talked about. I have to dumb myself down for my audience because I have to be dumber than my audience. I don't want to talk to my guests as a peer-to-peer, because if I do that, I'm going to talk over the majority of my audience. So I purposely dumb myself down to ask questions that, okay, maybe somebody doesn't even know what that word means, but you and I know what it means because it's in our lexicon. But for a new viewer, it's not. And I have to break that down for folks. So it's real easy for two people that are interviewing each other that, communicate, if not daily, but enough to where, you just mention a word, you don't have to go look it up in Black's Law. You don't need a Burton's Legal Thesaurus. You already know what it means in legalese. So it's easy to overtalk your audience, and that's what I try not to do. I try to break everything down for you as simple, possible, fundamental, elementary as possible, strictly for that reason. Dawson, I mentioned Dawson. Dawson is the database for the U.S. tax court. It's like PACER. If you've ever used PACER, PACER is the database for all federal courts, bankruptcy, district courts, appellate courts, and SCOTUS. So you can go find anybody who's filed anything, boom, just pop their name in there, and you can see all the litigation that they've done. Todd is he has a lot of postings in PACER, and one of my subscribers and former students, I would say an associate, a peer, in my Telegram, posted an Excel spreadsheet. I guess it was a screenshot. I kind of opened it up and glanced at it. I told you folks, I just don't have time to dig into stuff. It appears that most of his stuff doesn't have any traction. Now, I don't know enough about Todd's process or having researched his filings to be able to even make a statement at the present moment regarding the issue of why these cases just have a short shelf life. Okay, some of them 2 months, 3 months, 4 months, they're done. filed and they're done. So I don't know if they're dismissed because I haven't opened them up. I started opening up. I was like, God, man, there's a lot of them. And it cost me money to open up every one of these documents and read it. So I was like, I don't want to do this and go through all of this and come to an end result and then have to go back and pay for it again and emulate it to do a video. I was like, well, why don't I just wait and we'll all go do it together? Because, there's been a bunch of sensations on the horizon who say they've got the pot of gold at the end of the rainbow and that they can lead you there. But very few can provide the fruit. There's been a lot of people who talk, but a lot of people who just don't show the proof of success. Now, when I say that, I run on, listen, I've been doing this for a hot fucking minute, a hot minute. And this is the requirements that I have distilled from all these processes. You need two things: proof of concept, proof of success. Now, what that looks like is you have to have a process that somebody can look at and go, okay, I can do that. I can go find these documents. You show me the template, how to fill them out, where to send them. Okay, I can do this. All right, proof of concept. Proof of success, it has to work. And you have to preferably do it with two different things. So let's just say you're trying to discharge debt, property taxes, boom, credit card. I give it the analogy as a point of sale system for a debit card. So you have a debit card for your trust. You've got credits on account, right? You've been depositing funds in there. So you have credits on account. You take that debit card, you go to your point of sale system, you tap it for your goods and services. As long as there's credits on account, point of sale system is operable, no operator error, you're going to get your goods and services every time until the credits are expended, correct? Same concept. That's what I'm looking for. That's the standard I use for all of this. That's why, a lot of people won't even call me with stuff because they got the concept, but there's no proof of success, or if there is. And like people tell me, we had some friends did it, a husband and wife, and they both sent it off at the same time, same place, copied each other, and the husband got it, the wife didn't. And when you hear that, and you see that, and people experience that, it's like, okay, yeah, there are some one-offs, there are some successes, but it's not consistent. So I don't know anything about the full machinations of Todd's process. I'd like to learn it if it's functional, if it provides fruit, if there is a pot of gold at the end of the rainbow. I'm all in. If I have to pay to get that education or pay to get that consulting, I don't have a problem with that. I'll get a line right behind me. I've done it before. And I'm not going to call those people to go get in line behind me unless my standards are met. Proof of concept, proof of success, show me that you've done it twice. That's one of the reasons why I invited Todd to come on the show. It's like, hey, come explain all this, okay? Look, I'm a dumb little 5-year-old trying to do my own research. I'm trying to be not the class clown, but the teacher's pet. So I need to get up there and bark some language that she can fully understand. So it was, don't take it personal, but to me, it was disappointing in the reply I got back from Todd. I was, really? That's odd. I would think you'd want to talk to more people about your experiences and your knowledge, because isn't that what you're trying to do? Expand your audience, expand the education, expand the knowledge, put as many people as you can on this pathway to freedom and sovereignty, self-governance. I just, I try to connect the dots, and the dots just don't want to connect. It's like I'm pushing two North Pole magnets together. What do? They repel. So I don't know how to explain it, but I will I expressed my feelings. Yes, I was disappointed that he failed to provide a adequate rebuttal, because I try to treat people as I would want to be treated, with respect and dignity, courtesy, all of that, because that's how I want you to treat me. And if you don't treat me that way, guess what? That's the end of our relationship. So, um, I don't know if I, came off wrong on the invitation. Hey, man, hit me up. I can take critique just with the best of them. Okay, probably better. I got some comments, so let me get over here. Happy Unicorn. Again, welcome back. M. Heiser for you. How you doing? Thank you for joining the show. Brandon C. Hellman, same here. Welcome. I'm broke and a little jaded myself, but this tax season, I am ready to collect. Okay. Go out and knock you one up and get that $1,000 for your kid and put it in a trust. And I'm just kidding. David is awesome. I don't know which David that is. Telegram is great. Todd Duell is fantastic. Everything is a contract. Okay. All right. Well, thanks for all that. He sounds great. Everything sounds great. Sounds like it possibly works, but I want to know more. I want to ask more questions. I want to dive deeper down those rabbit holes. I just don't want somebody to tell me a story and then nobody try to punch holes in the story. You follow me? That's why I can't get most of these people to come on my show. I invite them, but they got holes in their boat, and they know I'm going to find the holes in their boat, and I'm going to sink their ship. And that's not why I came here on Todd. I really dig dive into his whole deal, what it's all about. I could care less how much people are settling for. Okay. I want to talk to you. I want you to fully comprehend that we need justification of how this really works. Nobody wants to watch, 24 videos, and albeit, Ann and I did 20. And God bless you guys for hanging in there and watching 20 minutes or 20 hours or 20 videos. There's not enough of us out there. So I've gone on and on. Let me get over here. What's this one? No, that's on the family offices. All right, let's take a ride. Come on with me. Here you go. Public access to PACER case locator. Let me get my happy ass off the screen. I know you didn't come here to see me. I'm sure most of you thought I was going to interview Todd. That was never on the agenda. I just reached out and provided an invitation to him if he wanted to come. But anyway, let me log in here so you guys can watch everything. There you go. Fearless Floyd. That's me. Hey, here we go. Fine parties. And as appellate, so there's your courts of appeals, there's your bankruptcy, civil, criminal, multi-district. These two right here are your federal district courts, your U.S. district courts. These are your, 9, 10 courts of appeal with D.C., and then your bankruptcy courts. So we're going to search all. And here's what we get, 17 results, right? Isn't that what it says right here? And make sure, yep, okay, we're sharing. So, excuse me. All right, that put them in consecutive order by filing date right here. So he popped up September 2020. Almost a little over 2 months later, this case was closed. The next one, and these are all Ninth Circuit Court of Appeals, California. I don't even know what these are. We'll go open them up and look at them. Here's one filed April 9th, 2021. A little over a month later, done. Here's one filed April 29th, 2021. A little under 2 months later, closed. Next one, November 23rd, 2020. December 7th, 2020, closed. April 8th, 2024, a month later, closed. May 2024, 6 months later, closed. June 22nd, 2020, went into March, about 9 months. March 30th, 2021, closed. September 24th, 2020 to October 15th, 2020, closed. February 20th, 2024 to May 29th, 2024, closed. November 8th, 2024, December 11th, 2024, closed. November 8th, 2024, that case is still pending. September 30th, 2024, closed. October 2nd, 2024. Another one, same date, closed, same date. Filed same date, September 30th, 2024, and that one lasted 2 months till November 1st, 2024, closed. Again, same thing, different parties, September 30th, 2024 to November 1st, 2024. The next case, December 26th, 2024, February 26th, 2025, 2 months. And last but not least, June 17th, 2025, and that one lasted a little over 2 months to August 27th, 2025. Now, we're going to go look at these. Obviously, Todd seems to be the plaintiff in all of these and not the defendant. So obviously, he's pursuing people or entities. So he's definitely pursuing persons. But we'll go take a deep dive in these. And hey, you know, maybe he's getting relief, whatever requested relief. So maybe some of these are mandamuses, some of these are petitions for something, applications, who knows? But we're going to dig in individually, and we're going to open up all the instruments that were filed and read them and see where we go. So let's go back to this first one, Todd Duell versus Abram Genzer et al. If you don't know what et al. Means, it means there are more than one defendant. There are more parties to this. They use the et al. As a Latin abbreviation to tell you that there are more parties available. Make sure my screen shared. Pop, there you go. If you view the full docket, you'll be charged for one page, 10 cents. So these are 10 cents a page. This is a prisoner's civil rights. So this is probably a section 1983, I would assume. Docketed and cause entered, appearance of pro se appellant and no appearance for appellees. Appellant Todd Duell opening brief. That was on September 24th, and then October 1st, filed clerk order to show cause, docket fee due. 2 weeks later, on October 15th, filed appellant Todd Duell, letter dated October 8th, 2020, confusion and notice of appeal, paper filing deficiency, none, And then November 30th, 2020, filed order, motion to dismiss case for failure to prosecute, Civil Rule 42-1, pursuant to Ninth Circuit Rule. That's what they call local rule 42-1. This appeal is dismissed for failure to pay fees. This order is served on district court. Shall 21 days after date of this order act as the mandate of this court. So what they're telling you is this order served on the district court shall 21 days after the date of the order of this date right here, the court will automatically issue a mandate. If you don't know what a mandate is, that means it's final. Stick a fork in it, baby. That's what that means. It's been finally adjudicated, no rights to appeal, period. So would y'all like to go open these up and look at them? So let's go see what all the fuss is about. This is 55 pages. Accept all charges and retrieve. Like I said, this is going to cost a little money to open all this up and look at it. That's why I would like Todd. Todd could have said, hey, go look at that case, or go look at that case. Open that case, go look at this document. Wouldn't that have been a lot easier? A lot more courteous, more appealing to my audience. Just saying. The hell? United States Court of Appeals, Ninth Circuit Office of Clerk, after opening your appeal, what you need to know. This guide is not legal. Okay, here's your guide. Huh? They give you a guide how to file. That's the first document in his case. Did I miss something? There's an informal pauperous form. Recognize that. I filled out a bunch of these. Motion for appointment of counsel. This is all part of the package, yes. Oh, wow. Boy, does almost everything for you. All the templates. All you do is just fill in the blanks. I guess with this, what they send to prisoners. They call prisoner package. Notices. All right. Duell versus Genser. Dear appellant, copy of your notice appeal petition has been received in the clerk's office. Blah, 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 blah. Need a payment of $505 docketing fee and filing fees for the ADEPA. Yeah, I won't even tell you what Congress did to increase this filing fee. The name of the act is so ridiculous, it's pathetic. This is the scheduling order telling all parties this is the dates, times, rules, procedures that we will operate by in this case. And more blah, blah, blah. So nothing there. haven't gone anywhere. Where was that? Okay, that's what it did. All right. I didn't realize it jumped tabs on me. I thought I was still on the same tab. Come on. There we go. All right, back here. This is where we was. This is the first case. So we read the beginning. We can read the middle. Let's read the end. Order filed. A review of the docket demonstrates that appellant has failed to pay the docketing filing fees in this case pursuant to the rules, dismissed for failure to prosecute. Yep. All right. Well, we just went through that one. Back over here. All right. So we just went through this case, right? That lasted the whole rocking 60 days. Somebody refused to pay the filing fee or file an application to proceed in forma pauperis, even though they provided the form. Next up, we have Todd Duell versus the United States District Court, California, LA. So he sued an LA District Court. Hey, been there, done that. Let's see how he fared. This one was filed April 9th, 2021 and lasted a hot rockin' month and like 34 days, 33 days to May 13th, 2021. So let's go see what this is all about. I'll share this tab. I like that. They fixed that finally. All right. Appeal from the U.S. District Court of Central California, Los Angeles proceeding. Original. It looks like it's a mandamus. And yes, that's what we have. Filed petition for writ of mandamus, docketed cause and entered appearance of pro se petitioner. Court update, new documents attached. The second entry on April 28th, 2021 received notice of change of address dated from Todd Duell. His new address is a suite in San Diego. Anytime you move, you're supposed to notify all parties of your new address. Again, on the same day, file petitioner Todd's motion for leave to amend writ of mandamus and or prohibition. Deficiencies none. Served on the 20th. And then May 13th, 2021, filed order. Richard A. Paez, Marcia S. Berzon, and Danielle J. Hunsicker. Petitioner has not demonstrated that this case warrants the intervention of this court by means of the extraordinary remedy of mandamus. See Ballman versus U.S. District Court. Accordingly, the petition is denied. Petitioner's motion for leave to amend the mandamus petition is denied. No further filings will be accepted in this closed case. Denied. So we can open these up, but he filed a mandamus. So let's go see if we can read the mandamus. Here we go. Petition for writ of mandamus. Can't tell you how many of these I filed. Ooh, somebody was actually in prison because they are writing on a legal pad in pen or pencil. Date, April 3rd, 2021, Emergency Motions Department, emergency relief. Happens that nobody answers the phone at 415-355-8020. I do not have access to email. Therefore, I had Julie Locke send me an email to you at emergency@ca9uscourts.gov to respond faster to me. Please call her at that number, and this is all public record, so is what it is. I'm not going to repeat it out loud. Please email me a copy of the Federal Rules of Appellate Procedure, Ninth Circuit Rules, Form 29. I need an emergency decision in fewer than 21 days, 10 or less requested, to avoid serious harm being intentionally allowed by the lower court, violating the U.S. Constitution, laws of the United States, and treaties, and refusing to recognize Uniform Commercial Code for federal security instruments and bonds. Number 4, I have an emergency motion for injunction pending appeal. The appeal order to show cause and arbitration agreement prepared. 5, respondents are in multiple defaults for equitable estoppel in an arbitration and continue to create significant financial damage at will by stepping in front of perfected security interest for an estate without consent or court order, exactly as predicted to the court via multiple writs and motions. And I guess this is number 7. District Court has not responded to 4 motions for reconsideration, arbitration, and default by respondents. In 4 months, there is no information in the PACER system. Nobody answers the phone, and nobody can go into the court due to COVID. Therefore, I need to send the appeal and motions directly to the Ninth Circuit Court to avoid threatened serious harm, to grant the requested settlement relief. Actual damages are in progress now. See case number, y'all can go look these up if you want. 20 means the year it's filed. CV means it's a civil suit, and that's the case number. That's the district judge assigned to it. That's the magistrate judge assigned to it. Yep. Please respond with instructions for how to get this emergency motion as soon as possible. Note, I do not have access to electronically file. Respectfully, by Todd Duell, Principal. And there's the envelope. And Principal is he's on Front Street. Can't make it up, folks. He's on Front Street. All right. So let me 86 that. And there's another petition. Let me get over here, open it up for you guys. All right, this is the number 4, and it's probably the same document. Yeah. Yep, same thing, just a duplicate. So there we got 2 cases in the drain. Couple more comments. Let me get these before everything gets crazy. M. Hazer for you. Thumbs up. Amen, brother. Did Todd Duell stand you up, or does he just not regularly check his emails? At Helia, I hope I pronounced that correctly. If I didn't, forgive me. I sent Todd a text, and he replied, but his first reply was to tell me about a success he had. Then the second reply about another success he had. And then I hit him up with, is that a yes or a no? Because you really didn't answer my invitation, whether you would or you wouldn't come on. You just told me about 2 successes. What am I going to do with that? So I waited an hour for him to reply. He didn't reply. I hit him back, quoting myself. I am not disputing your success. I've never done that. God, I hope he's correct and he has success consecutively and consistently. Yeah, that guy would, he'd be Mr. Popular. And I've seen these people blow up overnight and, flame out, and they still have a legion of people following them, and they're legal morons. It's insane. For years they've been doing the same crap over and over and over, dragging these people with them. And, like I said, it's insane. Let me get back over here. Yeah, we already went there. There, so I can 86 that, I can 86 that, I can 86 that, I can 86 that. Yeah, I got just so much stuff open, it's hard to keep track of. There we go. They all look the same. All right, here we are back at pacer.gov. So we've already gone through these two cases, the first two, 2020 and 2021. Here's one filed 20 days later than the last one we just did. And this is Todd Duell versus William Gore et al. I have no idea who William Gore is, but obviously there are more defendants to the party. And here we go. What do we have here? Oh, we have this is a state case. So this is Title 28 USC United States Code Section 2254 for a prisoner either in state or federal custody challenging a state conviction. All right. Open. Ninth Circuit docket needs certificate of appealability. So this would be his 2255. Or I'm sorry, no. Yeah, it'd be 2254. He doesn't have a federal case, that's a state case. 2255 is for a federal conviction. 2254 is for a state conviction, any state. So he's challenging the state conviction. He's trying to take it from the district court to the Ninth Circuit Court of Appeals. And when you do that with your notice of appeal, you have to file a certificate of appealability, and it has to be accepted by the court, called a COA for short. So he filed that April 29th. I wonder if he ate up his 1-year equitable tolling. We're going to find out. We're going to find out. Ninth Circuit docket needs the COA. And then 5 days later, filed clerk order. The record suggests that, see, and this is what I tell you, folks, the only thing that matters is the record. It's the only thing that matters. The record suggests that this court may lack jurisdiction over the request for certificate of appealability because the notice of appeal was not filed or deposited for mailing in the prison's internal mail system within 30 days after entry of the district court's December 8th, 2020 judgment, or within 30 days after the entry of the district court's January 21st, 2021 post-judgment order C 28 USC section 2107 lowercase a and FRAP, Federal Rules of Appellate Procedure for A1AC. Within 21 days of this order, appellant must move for voluntary dismissal of this request for certificate of appealability or show cause why it should not be dismissed for lack of jurisdiction. If appellant does not comply with this order, the clerk will dismiss this request for certificate of appealability pursuant to the Ninth Circuit Rule 42-1. And about a month and a half later, on June 21st from May 4th, filed order. On May 4th, 2021, this court ordered appellant within 21 days either to move for voluntary dismissal of this request for COA or show cause why it should not be dismissed for lack of jurisdiction. The order warned appellant that failure to comply would result in automatic dismissal of the appeal by the clerk of the court. To date, appellant has not complied with the court's order. Accordingly, this appeal is dismissed for failure to prosecute. This case is now closed. Bam! Did you hear that door slam? Ooh, that was loud. So y'all want to go open these up or not? I pretty much told you everything about them without even opening up and looking at them. So we can save time. We could be here a very long time. So moving on down Next, we have, again, Duell versus Gore et al., not to be confused with Albert Gore, former vice president. Anyway, here we go. Again, this case was filed November 23rd, 2020, and closed December 7th, 2020. It barely lasted 2 weeks. Let's go find out what this one's all about. Generally, this is what it looks like. So you can go history documents, or you can go here to the document report, and you hit run report, and it pulls all this up for you. Just go over here and you can read what's what. Here again, we have the petition for writ of habeas corpus, state telling you so. It's a 2254, Title 28, USC 2254. All right. So obviously, Todd was in San Diego Central Jail proceeding pro se. Okay. So me having been in prison for a shit ton of time, and in so much as had Texas change state law, prison policy, prison procedures, prison rules, prison documents, all behind my sweet little happy ass. Here we go. I get it. Correspondence is sketchy at best. So I can understand why he may have missed some timelines that were adjudicated by the court, and shit happens. I don't know his relationship with the actual jail staff. It could have been sweet, and it could have been not so sweet. So petition for writ of habeas corpus against William Gore, Xavier Becerra, filed by Todd Duell. $5 filing fee not paid. IFP not filed. So I'm reading the docket sheet because why? The record matters. So either Todd didn't want to pay the $5, didn't have $5 in his commissary, or couldn't have somebody pay it for him, and did not file the application for informal pauperis. The new case number, they gave it a new case number. Judge William Q. Hayes and Magistrate Judge Andrew G. Schopler are assigned to the case. So that means that the magistrate judge is going to do all the heavy lifting. And once he does his recommended order, he can accept it, and then you can appeal it back to this guy. Then you can go to the Ninth Circuit with your certificate of appellability. So fee for habeas corpus was paid on the 6th of October, transferred from California Southern, wherever that is. Case transferred to the Central District of California, Western Division. Files transferred electronically. Notice of change of address by Todd Duell. He transferred from California Southern to somewhere else. So that could have been an issue. Transfer, i.e. diesel therapy. If you are a thorn in the system will put you on diesel therapy. If you don't know what diesel therapy is, that means that you are bouncing around from one jail, transfer unit, custodial facility to the next every damn day for months on end. It never stops until they tell it to stop. By then, you are emaciated, physically, mentally, emotionally, and spiritually spent. Absolutely. That's why they call it diesel therapy. Mail returned as undeliverable. Reference, 3 cases transferred out to another district. So when they bounce you around, your mail's chasing you around and it can't catch up to you because they're bouncing you. You're on that diesel therapy run. Here we go. November 24th, filed original file, certified copy of transfer order and docket sheet received from California Southern. On the same day, we have notice of reference to U.S. Magistrate Judge. This case has been assigned to the calendar of the Honorable District Judge Percy Anderson and referred to Magistrate Judge Sashi K. Kelaramanani, who is authorized to consider preliminary matters and conduct all further hearings as may be appropriate or necessary pursuant to local rule, blah, 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 blah. Did I not tell you that the magistrate judge was going to do all the heavy lifting? Financial entry received $5 into the registry of the court for Todd Duell for his petition for writ of habeas corpus, section 2254, challenging a state conviction. Now, I don't know if Todd's running from this or not, because it's, as far as I know, I've never heard it mentioned once that he was incarcerated or went through this. But this would have been just a great conversation, definitely a barrier breaker between Todd and I, because we could have discussed this. We could have bonded, become bosom buddies and everything. Obviously, I don't know what the fuck I'm talking about, right? I know, doesn't it all sound just arcane and, like I'm just stumbling over everything? I thought so. Just making sure. Remember, I'm dumber than a box of rocks. I don't give legal, financial, medical, or even emotional support. I'm just not that guy. 10, order denying petition, dismissing case, and denying a certificate of appealability by Judge Percy Anderson. Reference, petition for writ of habeas corpus 2254. See document for details. Ooh, we're going to go have to see that. Here it is. Judgment by Judge Percy Anderson related to order denying petition, dismissing case, and denying a COA. It is hereby adjudged that this action is dismissed with prejudice. SpaghettiOs. Declaration filed by petitioner Todd Duell. We're definitely going to take a look at that one. And order denying declaration of war. What? And petition for review by Magistrate Judge Sashi Kelaramanani. Got it better that time. And then next up, we have here a month later in January, motion for reconsideration. And we have an order denying motion for reconsideration, petition for reconsideration, and petition for reconsideration, notice of discrepancy and order. Oh, I'm going to open all this up just to go look at it. Notice of discrepancy and order by Judge Sashi H. Kawarmani, ordering notice of settlement agreement by arbitration agreement submitted by petitioner Todd Duell, received on March 30th, 2021, is not to be filed, but instead rejected. Denial based on document does not contain an open, active federal case number. Document may not apply to this case or this court. Named respondents do not apply to any parties in this court. Next entry. Disregard this entry. No attachment. So the clerk screwed up somewhere. Next entry. Report and recommendation of the United States Magistrate Judge to deny petition for reconsideration and deem petitioner a vexatious litigant issued by a magistrate judge. Ooh. Hey, join the club, Todd, because guess what, buddy? I am a vexatious litigant in the state of Texas. Thank you, Judge Keeling. Appreciate you. Thank God you have passed on. That was the judge where I was in the Walker County grand jury room arguing with a free world attorney who was hired by the Texas Attorney General to accompany his assistant Texas Attorney General to litigate against me while I was all restrained, like you would see the most violent, heinous convicts being confined without a cage and having to litigate that way. And that was the judge where we were in a debate or friendly discussion, because we ended it friendly, whether or not that the state of Texas was a republic or a corporation. Oh, yeah. That was a great discussion. And I was trying to find the Dun & Bradstreet background business report, but of course, of my restraints, I was unable to circumvent thousands of pages of legal documents to find 3 pages to prove to this judge that actually he was working for a corporation. He was part of this big machine, and he was just another little pissant cog in the machine. Absolutely. I don't know what the fuck I'm talking about. I'm just making shit up as I go along. I wish. Here we are. Notice of filing report and recommendation. The vexatious litigant deal, notice of appeal, and other documents to the Ninth Circuit filed by petitioner Todd Duell. Looks like Todd was a writ writer. So it's looking to me like he went in here and just gnashed away until he learned. And I don't know where that education took him. So we're going to find out. So obviously this has been in the last 4-ish years. Order accepting report and recommendations by Judge Percy Anderson, petition for consideration. So let's go read the petition. Because the petition, guess what? That's the record. It's the only thing that matters. Oh, we can't get the petition. Notice a change of address. Notice a reference. Yeah. Ooh, civil cover sheet, 1 page. Well, I don't want to look at that. Fee paid. I want to read the petition. Original file. Restricted. That's odd. So that's sealed. I can't look at that. All right. Well, let's go back to box number 2. Let's go read it all. There's the receipt for the $5 payment. Yes, I want to stay on. Damn it. DUELLTODD. Yep, you guys are with me. All right. So we were right here, yeah. The second gore. Let me go back and look at these history documents, see what we can find there. Rankiri, petition for writ habeas corpus. That one's same thing. Civil cover sheet. Ooh, here we go. Federal question. Original proceeding to habeas corpus general 530. No, their boxes are checked over here. Jury demanded no. Petition writ habeas corpus, check if this is a class action. No. That's a thing, just in case you didn't know that. Habeas petitioners can file as a class. All right. California Institution for Men. All right. Let's go back to that one. So we did that. So run report again. We're back over here. Case transferred. So we're going to look at this document. That one's sealed as well. So they transferred it to a different district. What popped out? All right. Back over here. Sorry about that. I don't know what popped out. All right. So we just looked at number 3 right here. Notice of change of address. That's not what we need. Mail returned as an undeliverable. No. Original file. We've already looked at this. Note of reference. Case has been assigned. Financial entry. Petition in support of writ of habeas corpus. So let's go look at that. All right. Todd Allen Duell, living man. Now he's propria persona in vivis. So he's proceeding pro per, no longer pro se. United States District Court, Southern District of California, a petition for review in support of writ of habeas corpus under 28 U.S.C. Section 2254, fraud upon the court by the clerk of the court by a person in state custody. Petitioner appears specially without waiving any rights, remedies, or defenses, statutory or procedural, by and through Todd Allen Duell, living man, in his capacity as principal, hereafter principal, an international organization in accord with the premises of 18 U.S.C. Section 112, an internationally protected person who petitions the court for relief. As grounds for said petition, petitioner states as follows. This is his mailing address, obstruction of justice, in docket entry for that case. Okay, in this court's docket entry, so there's a bunch of docket entry errors, and I've been through this. Oh God, this is a nightmare when you're dealing with docket entry errors. It can get real screwy, and you're not even focused on relief anymore. You're dealing with a bunch of drama bullshit that they created. They love to throw this and get you off track. This is one of their tactics. Principal petitioner has sought a redress of grievances in accord with permanent injunction known as the Constitution for the United States of America and the State of California Constitution therein. Principal petitioner is due his day on court on the habeas corpus petition in accord with 28 U.S.C. 2254. Principal petitioner has good faith belief that the clerk of the court is obstructing his meaningful access to court's case law and necessary prisoner in state custody. Petitioner has brought this action to obtain relief in regard to 4 specific issues for resolution. Number 1, recognition and enforcement of agency termination. Number 2, recognition and relief to violations of 27 CFR 7211 and Black Diamond SS Corp. Versus Robert Stewart and Sons, 336, volume 336, United States, page 386, 1949, wherein respondents can have the vessel, man, or the bonds for penal sum charges, but not both. Number 3, prison condition violations. And 4, no access to a law library in accord with premises set forth in Turner versus Rogers, 131 Supreme Court 2507, 2011, and the right to counsel violations in accord with Ferretta versus California, another Supreme Court case. Whenever you get admonished to represent yourself in court, they give you what's called the Ferretta admonishment. And that's where they tell you, you're your own worst enemy. You're your own worst client. You probably should retain counsel. If you can't afford one, we'll appoint one to you because we got plenty of clowns. Court jesters aplenty. Update. Due to the delay in justice, the following has changed. Number one, count one stated above has been violated as state court refuses to acknowledge said agency termination and continues to physically abuse principal petitioner. Number two, count two stated that the above has not changed. Number three, count three stated above is still effectively restricted as principal petitioner is confined to the San Diego County lockup, wherein access to a law library is effectively restricted in violation of law. And four, principal petitioner is tentatively being allowed to defend himself, but judge is attempting to engage in barratry and act as in the nature of embracery agent at the same time in violation of law. Number 10, petitioner reminds his court that principal is the owner of all securities associated with the name Todd Duell. Number 11, principal petitioner reminds the court that principal has no agency agreement with respondents or with the United States. See Exhibits 1 and 2 and list of exhibits in support of petition for writ habeas corpus under 28 U.S.C. 2254 by a person in state custody. Because there is a severe delay in the justice due to the numerous obstructions due to custody, petition, prison clerks, corrections officers, perceived agents of the state ad nauseum, etc. This document was read to principal petitioner, and he has agreed to have it mailed into the court as stated. If judge believes this document was produced without the knowledge of the principal petitioner, then writer demands that you order the appearance of principal petitioner, and he can authenticate demand for hearing. And it has a facsimile signature, which in the state of Texas is 100% lawful and legal. And why, Floyd? Why? Why did the Texas Supreme Court make it lawful and legal via the Texas Supreme Court? Because Harris County grand juries and prosecutors just willy-nilly took rubber stamp signatures of grand jury foremen and assistant grand jury foremen and rubber stamped the hell out of indictments. That's probably where the term, they could probably indict a ham sandwich. I'm sure that came out of Harris County. But at the onset, when it was recognized as a legal loophole or technical error, it was exposed, it was abused until everybody realized, oh my God, we got murderers overturning their convictions because there's a facsimile stamp on the grand jury indictment. And then they changed a whole bunch of laws. And basically, if you do not challenge an indictment before prosecution, you waive your rights to challenge the validity of the indictment unless it contains a jurisdictional defect, which can be brought into the court at any stage of the proceeding, even after mandate. You're welcome. Certificate of service. Obviously, Todd had somebody on the outside working for him, with him. Kind of odd that the green card would also be included in here, unless that's a facsimile copy showing that it was sent to other parties. Why does that keep kicking off? That's weird. All right, so back to this one. Here we go. All right. So here's the petition that we just read. Petition for review filed by Todd. Obviously, somebody else did this. He didn't generate it. I mean, he could have maybe told somebody what to do, what to type. This looks like more of the same. Yeah. Same document, just a different filing. They do this, and it muddies up the record. They file the same stuff over and over and over. All right. Finally got around that one. Order denying petition, dismissing the case, and denying certificate of appellability. So let's go see how they treated our young man here. Background. On July 11th, 2020, petitioner Todd Duell, petitioner and inmate housed at San Diego Central Jail proceeding pro se, constructively filed a 133-page petition for writ habeas corpus under Section 28 USC, Title 28 USC, Section 2254, in the United States District Court for the Southern District of California, purportedly attacking a February 2019 judgment of conviction that was entered in the Ventura County Superior Court, electronic case filing number, blah, 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 blah. In petitioner's lengthy petition, petitioner raised the following four grounds for relief: that petitioner terminated all agency relations with the United States and state of California. Number two, respondents violated the doctrine of 27 CFR 72.11, commercial crimes defined, and Black Diamond SS Corp versus Robert Stewart and Sons. Commercial liability applies. Number three, prison conditions violations, George Bailey Detention Center. And number four, George Bailey Detention Center does not allow petitioners to timely access a law library, which is a heinous stain upon our judicial system. That's why I say the whole system has to be scrapped and rebuilt. Something much less restrictive, more open, and of course more accountability, because when you put people in positions of power, they have a greater responsibility and liability, and their accountability should be greater than the charges in which they were appointed or elected to work for. So let's see. I do not see why he was even locked up. On November 24th, 2020, this court received a document entitled Petition for Review and Support of Writ Habeas Corpus under Title 28 USC, Section 2254, fraud upon the court by the clerk of the court by a person in state custody, supplement, in which petitioner informed the court that he was proceeding as a living man in his capacity as a principal and international organization in accord with the premises of 18 USC, Section 112, an internationally protected person who petitions the court for relief. In petitioner supplement, petitioner states that principal petitioner has sought a redress of grievances in accord with that permanent injunction known as the Constitution for the United States of America and the State of California Constitution. And petitioner alleges obstruction of justice or fraud upon the courts by the clerk of the court in pertinent part because the court could not effect the transfer of the case due to a lack of address of petitioner. Petitioner also included an update in a supplement in which basically we've already stated. I'm not going to repeat it. And here's the discussion of the court legal standards, screening the petition. And this is everything they throw up there to basically kick the bitch out. Finally, a court may dismiss the petition writ habeas corpus either on its own motion under habeas rule 4 or pursuant to respondent's motion to dismiss or after an answer to the petition has been filed. So conditions of confinement. Trying to see what the hell he was in jail for to begin with. Yeah. I mean, these are all civil rights, living conditions, meaningful access to courts. They're not brought up on a 2254. They're brought up on a 1983 or what else, Floyd? What else, Floyd? Come on, talk to me. How about you, Todd? What do you think that? Todd's not here. Damn it. See what happens? You invite your friends over and they don't want to come out to play and you feel all rejected and disappointed. That would be a civil RICO under 18 USC 1961 through 69. Yeah. You can actually do a duel. See, right here they're telling him, Section 1983. And this is what I talk about. I'm not going to call Todd a legal moron because obviously he's got some kind of snap. I've never talked to the guy. I talked to Chris Hauser, and I talked to Patrick Marino, so I can call them legal morons. But I haven't talked to Todd, so I can't make that determination whether he's a legal eagle or a legal moron. But we can just go by what his status was at this time in 2020 and 2021. He's obviously arguing the wrong issues with the wrong legal vehicle in the wrong forum. Absolutely. And, maybe he learned his lesson. Maybe he learned the hard way. And this is learning the hard way. For example, petitioner supports these claims by asserting that respondents were not allowed to keep petitioner vessel, aka principal, in custody after bonds posted for settlement because petitioner terminated agency, thereby revoking legal title to said Todd Duell estate trust from U.S. Attorney General and State of California post New Deal construction and merged legal title and equitable title, thereby collapsing said trust. Petitioner adds that he reserves his rights to provide arbitration with respect to his second claim. As best as the court can understand petitioner's first and second claims, relying on a finding that petitioner is now a, quote, vessel, close quote, because he has somehow, quote, revoked legal title, close quote, from his name and is thus not subject to prosecution or conviction by the U.S. Attorney General and State of California. The court finds that petitioner's first and second claims are, quote, patently frivolous and false, close quote, and therefore are subject to summary dismissal, which means you're out of there, buddy. We know you're so far out there, we don't even have to look at the rest of your shit. We're just going to dismiss this. That's what that means. I've read this hundreds of times, so I already know what's coming. With respect to and this is here where they're just like kind of, hey, we're still cleaning house. Moving on. No need to look over here. None to see. Case dismissed. Don't worry about it. Dog don't hunt. With respect to petitioner's third and fourth claims of 3 prison conditions violations at the detention center and doesn't allow access to law library, which means meaningful access to courts, which should have been brought up on a completely different legal vehicle. So they're kind of a moot point at this time. Accordingly, the court finds that plaintiff's third and fourth claims are also subject to summary dismissal. Additionally, the court finds that petitioner's supplement did not cure the above discussed deficiency with petitioner's petition. For example, petitioner's asserted legal theory in his supplement that he is a, quote, living man in his capacity as a principal and international organization in accord with the premises of 18 U.S.C. section 112, an internationally protected person, close quote, does not cure plaintiff's claims in his petition because petitioner's self-designation as an international organization and thus, quote, an internationally protected person, close quote, is patently frivolous or false legal theory and is subject to summary dismissal. Similarly, unpersuasive is petitioner's allegation in his supplement of obstruction of justice and fraud upon the court by the clerk of the court, because the court could not effect the transfer of the case due to the lack of address of petitioner. As discussed above, this case was transferred from the Southern District to this court on September 15, 2020, over 2 months before petitioner filed a supplement on November 24, 2020. As such, petitioner's allegation of obstruction of justice and fraud upon the court because the Southern District could not transfer the case is also patently frivolous and or false and subject to dismissal because the transfer occurred over 2 months before petitioner alleged that the court refused to transfer the matter. Because it appears that no tenable claim for relief can be pleaded even if petitioner were granted leave to amend his petition, the court finds that dismissal of petition with prejudice is warranted here. Certificate of appealability, and they're probably denying the certificate of appealability right here. A motion to reconsider denial does not extend the time to appeal. And this is where you have to hit the machinations for the equitable tolling of ADEPA, anti-effective death penalty and terrorist act. Yeah, you heard me correctly. So basically, when you are not in court, that equitable tolling of 365 days begins to toll. 365, 364, 363, 362, and so on. Every day you are not officially filed in court with a patently lawful legal vehicle, that equitable tolling ticks away. Once you have expended 365 days without filing your federal writ of habeas corpus or having permission to do so untimely, you are time barred. Under 28 U.S.C. Section 2253C2, a COA may issue, quote, only if the applicant has made a substantial showing of the denial of a constitutional right, close quote. The Supreme Court has held that this standard means a showing that, quote, reasonable jurists could debate whether or not, for that matter, agree that the petition should have been resolved in a different manner or that issues presented were adequate to deserve encouragement to proceed further. Slack versus McDaniel, that's a huge case. Here, and duly considering petitioner's contentions in support of the claims alleged in the petition, the court finds and concludes that petitioner has not made the requisite showing with respect to any of those claims. Accordingly, the COA is denied in this case. Order, based on the foregoing, it is ordered that the petition is denied. Judgment be entered dismissing the action with prejudice, and certificate of appealability, COA, is denied. December 7th, 2020, Honorable Shashi H. Kawalaramani. Boy, gotta say that quick. So we just read that one, right? God, why do they keep kicking me out? All right. So we've just been through 4 cases right here. Next up, we have the Duell Family Trust et al., which means there's more than one plaintiff, versus Donna Mae Duell Trust et al. I don't know who Donna Mae is, but we're going to go find out. Maybe I'm opening up some skeletons that Todd just didn't want to talk about. I don't know. So here we go. Docket report. We're going to run report. Right here. Somebody's demanding $1,100. We have a 28 USC 1332 diversity action. This sounds interesting. Plaintiff, Duell Family Trust, proceeding pro se. Plaintiff, Todd Allen Duell, trustee. And obviously he's in Hawaii here. Date filed April 8th, 2024. Why did we jump so far ahead? Oh, okay. I thought we were going in consecutive order. What happened to that? These jumped out of sequence for some reason. All right, well, we'll go look at it anyway. All right. So what do we got here? Donna is the grantor and a trustee. Miscellaneous party, Kelly Elizabeth Duell, and I would assume that would be Todd's daughter. You never know in California. Complaint against Donna Mae Duell Trust. Well, let's find out. Civil cover sheet, declaration of service, envelope. Filed. So right here we have personal property, other fraud. So we have trust fraud. Original proceeding, cause of action. U.S. civil statutes under which you are filing is the 28 U.S.C. 1331, 1332, theft of monies due to the Donna M. Duell Trust. He's demanding, that was not $1,100. That is $1,100,000. More instructions. All right, let's go back to that one. All right. Motion for leave to proceed form of paupers filed by Todd Duell Family Trust. Summons returned executed by Todd Duell, Donna Mae Duell Trust served. Application for default judgment against Donna Mae Duell Trust by Todd Duell to reflect application for clerk's default entry. Application for default judgments against Donna Mae Duell Trust. Application for default judgment against request for entry of clerk default against Donna Mae. Can't get him to do anything, can he? Filed in error. And here we go. Order granting motion to proceed in form of pauperous screening complaint pursuant to 1915 of Title 28 U.S.C. Affidavit in support of complaint by Kelly Elizabeth Duell. Let's go read the order. Here come the judge. Plaintiffs allege that Todd Duell is the trustee of the revocable Donna M. Duell Trust, which operates out of California. Plaintiffs allege that Donna Mae Duell is the grantor and trustee of the revocable living Donna Mae Duell Trust, which operates out of Hawaii. Plaintiffs allege that on December 15, 2020, Donna Mae Duell wrote check number 478 from the irrevocable Donna M. Duell Trust bank account at J.P. Morgan Chase Bank to herself, Donna Duell, in the amount of $200,000. Plaintiffs allege that according to the memo, it was a transfer to UBS account number and that the account number is for the revocable Donna Mae Duell Trust. Plaintiff asserts that Donna Mae Duell did not have the legal authority to take funds from the irrevocable Donna M. Duell Trust as the grantor back to herself and place them into her grantor revocable living trust, Donna Mae Duell Trust. Similarly, plaintiffs allege that on September 27, 2022, Donna Mae Duell sold real property in Nevada owned by the irrevocable Donna M. Duell Trust for $900,000. Plaintiffs allege that Donna M. Duell Trust did not receive the profits or proceeds from the sale. Plaintiffs believe that the money was transferred to UBS or Tracy L. Duell Casas in the name of revocable Donna Mae Duell Trust. Plaintiffs assert that Donna Mae Duell did not have legal authority to take real property or funds from irrevocable Donna M. Duell Trust as a grantor back to herself and deposit it into her grantor revocable living trust, Donna Mae Duell Trust, nor place the funds under the custodianship of any other person or other than the trustee for the Donna M. Duell Trust. Plaintiffs also filed an application to proceed in the district court without prepaying fees or cost, IFP application. In their IFP application, plaintiffs explains that the trust does not have a bank account or any property as a result of the embezzlement and that the trustee is disabled and on SNAP and Medicaid. Plaintiffs attached an affidavit in support of informal paupers affidavit. In their IFP affidavit, plaintiffs assert that Donna Mae Duell bankrupted the Donna M. Duell Trust when she moved all the assets and money from the irrevocable Donna M. Duell Trust to the revocable Donna Mae Duell Trust. Plaintiffs also assert that Todd Duell was paralyzed in the hospital from September 2021 through November 4th, 2022. So a little over 14 months. Plaintiffs assert that he had nothing when he was released: no clothes, no money, no place to live, and for all intensive purposes is homeless. Plaintiffs assert that Todd Duell receives $290 a month from SNAP. Legal standard. A motion to proceed informal pauperis presents two issues for court's consideration. First, the court must determine whether an applicant properly shows an inability to pay the $405 civil filing fee required by this court. To that end, an applicant must provide the court with a signed affidavit that includes a statement of all assets, which shows inability to pay additional fees or give security. Secondly, requires the court to evaluate whether the applicant's complaint sufficiently states a claim upon which relief may be granted. That's Rule 12b-6. 1915E only permits but requires the district court to dismiss an IFP complaint that fails to state a claim. The court addresses each issue in turn. Discussion. The IFP application. An applicant need not be completely destitute to proceed IFP, but he must adequately prove his indigence. An adequate affidavit should allege that the affiant cannot pay the court costs and still afford the necessities of life. Blah, 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 blah. And here plaintiffs assert that the trust, presumably the Donna M. Duell Trust, does not have a bank account or any property. Plaintiffs also assert that plaintiff Todd Duell has nothing and receives only $290 from SNAP each month. Based on these limited facts, the court exercises broad discretion and grants plaintiff's IFP application. Screening under 1915. Above, every complaint filed pursuant to the IFP on 1915 requires mandatory screening. So when you don't pay that filing fee, your shit gets screened, and generally you get booted under Rule 12b-6 for failure to state a claim for which relief may be granted as frivolous and malicious and dismissed with prejudice. I've seen that so many times. Under this provision, the court must dismiss complaints that are frivolous or malicious, or failure to state a claim on which relief may be granted, or seek monetary relief from defendants who are immune from such relief. The rule requiring entity defendants to appear only through counsel applies to trusts. So take a note of that, folks. If you're in California, you cannot go defend your trust. You have to be represented by an attorney. Ouch. However, there is an exception to the general rule. An individual who is the trust beneficial owner may appear pro se on the trust's behalf. Here, plaintiff Todd Duell appears to be representing the Donna M. Duell Trust in its capacity as trustee. Plaintiffs request that the stolen funds be returned to the Donna M. Duell Trust, not to plaintiff Todd Duell personally. However, plaintiff's complaint does not allege any facts suggesting that plaintiff Todd Duell is the Donna M. Duell Trust's beneficial owner. Therefore, plaintiff Todd Duell is barred from representing the trust without retaining counsel. Conclusion. This means the end. That's what a conclusion is. We're concluding, we're closing the case. Based on the foregoing, plaintiff's IFP application is granted, but plaintiff's complaint is dismissed. Given plaintiff's pro se status, the court will give plaintiffs one opportunity to retain counsel and amend his claims in accordance with the above. Any amended complaint must be filed on or before October 14th, 2024, so ordered. Dated October 1st, 2024. Honorable Ruth Bermudez Montenegro, U.S. District Judge. I don't know why it keeps kicking me out of there. Okay. I mean, Kicking me all the way out. Whoops. One too many. All right, so we just dug into that one. Thought, oh no, we dug into this one. I don't know why they got out of order like that. There's Gesner. Here's another one, Gesner. Here's another one, Gore. So we know what these two are about. They're more prison litigation or jail issues, or is 2254. We can go over all those. I'll tell you what. I don't know who these people are. I opened up these two. I don't remember what they are. Let's go check out this one. All right, is referred to Fair Debt Collection Act under Title 15, Section 1692. Consumer Credit, Todd Duell, California Department of Corrections for Rehabilitation. Defendant Jeff McCober, Secretary. Defendant California Franchise Tax Board. Defendant Selvi Stanislaus, Executive Officer. Defendant Malia Cohen, State Controller. Complaint against all defendants. Let's go read the complaint. Got exhibits. These two are restricted. What's up, Doggity Dog? Here, we're going to look at all of it. 23 pages. Ooh, it's going to break me. What, Doggy? What do you want? Well, hello. I'm clicking. Nothing's happening. It's slow bucking on me. Let me take down my Brave shields. See if that worked. And that did not. See if we can get A and B to open up. Hello. Non-negotiable notice of debt validation request. This notice and enclosures of private communication to the parties and constitute due process and administrative procedure. Notice to agent, notice principal, notice to principals, notice to agent, applicable to all successors and assigns. Where's your citing to back this up? That would be restatements. Notice to principal doctrine. Todd Duell in Hawaii. Man, it must be nice. Get out of jail and go straight to Hawaii, right? This notice serves as formal notification in accordance with 15 U.S.C. Code Section 1692 that debt referenced above is contested and disputed either partially or entirely under the Fair Debt Collection Practices Act, FDCPA. All collection efforts regarding this account are to be suspended. Oh, sorry. There you go. And this is recent. This is February 21st, 2025. I declare that the account in question holds inaccurate or fraudulent information. I did not authorize, nor did anyone under my authority, the disputed transactions. Any further attempts at solicitation of this kind will be reported to the U.S. Postmaster for potential mail fraud, as it involves the use of U.S. mail to promote a contract that may be fraudulent or misleading, or to the U.S. Attorney's Office for wire fraud, as it involves wiring money from my bank account. It's not wire fraud until you transfer the money. Under 15 U.S.C. Section 1681I and 1692E8, you are required to promptly notify all credit reporting agencies, CRA, or credit bureaus about the dispute. It is your responsibility to direct them to delete any negative information pertaining to the accounts in question. Additionally, failure to verify with the credit bureaus as of the current date inaction regarding these demands constitutes a breach of FCRA, FDCPA, which may incur the associated fines and penalties. Verification, validation are demanded and require verification and validation are distinct terms and concepts as highlighted by their definitions. Verification involves confirming the accuracy of a claim, such as the existence of a debt, while validation is the process of ensuring that a product or service meets the requirements and expectations for which it was intended. Both play crucial roles in different contexts, ensuring reliability and compliance with standards. See Chaudhry versus Galarizo. Validation is for disputing a debt, stopping an account, credit reporting activities until debt has been confirmed. Verification, validation requirements. This looks like to be a 9-pager. Copy of the court bid performance payment bond bearing major CUSIP number, CUSIP numbers, and the gap accounting. Please also answer, how did you step in front of the lien on my minor account to acquire my funds as a trustee, secured party creditor, holder in due course, and principal owner of the estate, Todd Duell? Are the funds in this security not my property as the secured party and beneficiary for set off and discharge? That's a question, not a demand. And 18, please answer, is it not private trespass and unauthorized practice of law if the state actors' bonds are arrested and attached to the case trust, which is a security at bar? Is this not a violation of restraints of trade? 15 U.S.C. sections 1 and 2, 18 U.S.C. sections 472, 475, 2073, 26 U.S.C. section 7201, and SEC rule 10b-5, as well as identity theft, IRS form 14039, to create the court's bid, performance, and payment bond without my knowledge or consent. Again, another question. Please answer, why has the clerk of the court repeatedly refused to cancel and discharge the court bonds, IRS 1099-C, and process a GSA discharge bond lodged in the case in accordance with 28 U.S.C. sections 2041 through 2045, 48 CFR Chapter 1, Section 53.228, and 41 CFR Section 105-55030, 31 U.S.C. Section 3123, and Title 26 U.S.C. Section 6325, UCC Section 3-601 et sequetra, which means 601 and on, and any others as they may apply. Is this not akin to refusal of tender, which is discharged to extend of the amount of the tender, UCC Section 3-603B? And again, that was a question. Opportunity to cure. So here we go with the opportunity to cure and contest. Future communications, notice of demand for payment. And you can go pull all this up. Case law and judgments against debt collectors. And I'm approaching on 2 hours, so I want to chop this up. But anyway, that's where we are. I'm at 2 hours. I could go on, and actually I'm at 1:10. I started 10 minutes late, so I have 10 more minutes. So for those of you who stuck around to the end here, thank you. Obviously, it looks like I'm going to do a part 2. I don't want this to be a 4-hour video. I'd like everybody to make up your own mind about what you see, what you read, what you hear, what you research on your own. Again, this is not a hit piece on Todd. I just want to go, hey, bro, what are you doing? Sounds interesting. Sounds plausible. If it works, I want in. So how can I get in? How can I fit in? And sadly, my invitation was ignored, I guess. Because I didn't even get a yes or a no or a maybe or I'll think about it. Or I didn't get any of that. All I got is, hey, we have two of these successes. They're our two biggest, of course. You know, I could care less on the amount. If it was for 10 cents, I would be cool with that because you know what? You won. And I want to win because it doesn't matter what you win, just as long as you win, right? So we all want to be winners in this game, and it's a long game. It's hard. It's a struggle. And it sucks that there's so many people with misinformation, disinformation, greed, ego, narcissism, and you know, they want to be the smartest person in the room. And hey, if I'm the smartest person in the room, I'm in the wrong house, wrong building. I don't want to be the smartest person in the room. That's why it's so difficult for me to go out and socialize and mingle with people and try to meet girls to go out with, just to do things with, because there's such an intellectual disconnect. I mean, these people are just so stuck on stupid. You know, they're talking about some series that they're watching on Netflix or one of the legacy medias, or, you know, or they're flying, chasing their professional team from stadium to stadium to stadium to stadium like groupies just for the enjoyment of rooting for their team. What a waste of time, money, and energy. So, like I said, come on this journey. This is not a hit piece for Todd. I invited Todd on the show. I'm going to preface that, and that's my caveat. If I went places that he didn't want public, well, guess what? It's all public information, bro. File a motion to seal. That's all I can tell you. But obviously, I see that there was a major jump in his legal acumen from 2021 to 2025. A lot of knowledge gained, obviously. Now, why some of that information would be filed in those courts and not into the tax court per se, that's an answer I can't give you. And I don't know. I don't know if that's a rule. I just haven't investigated it. So I don't know. It would be a great question to ask Todd. Excuse me. Right? That's why I wanted Todd here, because everybody he talked to, they were just like, oh, that's so fascinating. And it just like, whoosh. Or he was talking to them and they understood everything and he talked completely over the audience. Because sometimes you have to slow down and you mention a form like 14039. Well, hey, you know, I talked about it here. Let's go take a look at it real quick. Let me explain it to you. Or, hey, stop. What is the 14039 form? Can you tell us a little bit more about that? So they just softballed him. They let him tell his story, and nobody, you know, stopped him and said, hey, tell us a little bit more of that, or break that down for the audience. So the people that have never opened up a Brack's Law Dictionary, but, you know, they want freedom. They want sovereignty. They don't want to pay taxes. They want to self-govern. They want out of this fucking slavery matrix we're in. And you're talking right past them, over their head. You're already handicapping them as soon as you open your mouth. So I invite people to my show for a reason. I'm not here to ambush anybody. I'm searching for the truth. If you don't have the truth, then don't come on the show, because you're going to get exposed. I'm going to expose you. I'm going to ask questions. I'm going to try to dive as deep as I can, dumb it down to ask the most kindergartenish ass stupid questions. And we're going to see where we go. Hopefully we find the pot of gold in the rainbow and some leprechauns dancing around it and going, oh, those are some real deals, huh? Y'all are cute. Oh, y'all are little bastards. Mean son of a bitches. Kicking you in the shin as they go around in their little circles. Right? I got to throw humor in here and lighten the mood a little bit because that was some pretty damning information we just read, because it didn't appear to me that Todd had a leg to stand on any of that. Which I don't even want to address that in this video. We'll do a part 2. I don't know when. Tomorrow night, tentatively, I have scheduled the fabulous Carmen Maria but Social Security's going digital, folks. JB Watchman, thank you for joining the show. What am I going to do part 2 for Todd? That's a good question. I could do it tomorrow night. I don't know. Subscribe to my channel, so I will schedule it, and I will give you guys at least 24 hours headway, if not more. I would definitely, again, I will text Todd again, and I will ask him to come on the show. Hopefully he caught the very beginning of it and, realized that, hey, maybe I did make a mistake. Maybe I should have accepted and come on the show and talk to his audience. You're more than welcome. I appreciate it. Thank you for subscribing. You don't have to become a member, and that's for a whole nother thing. It's only 99 cents a month. If I could make it a penny a month, I would. That's the cheapest I could make it. Yeah, sorry about the screen thing. StreamYard is improving. Almost daily, they're adding something new, and it's just me getting familiar with going back and forth, because now, used to, you had to stop your screen share, go back over, open your tab, go back to screen share, open it up. Now you can actually click and it'll change your tab. It's asking you, do you want to watch this tab or the other tab? So that's new and it's different. It's brand new for me, actually. So that's why I missed a couple of them. So forgive me on that. By no means am I a perfect person. Never claimed to be. I'm just some dumbass sitting in front of my laptop talking to it like a moron, like somebody's insane. So if anybody was in the background and had no idea I was doing a live podcast, they're like, man, that guy's crazy. He's over there mumbling to himself. So if I don't do anything before the weekend, everybody have a safe, glorious, happy, safe, warm weekend, because I understand it's going to get real cold up north. God bless everybody. Thank you for coming over here and spending your time, money, and energy with me. I hope you got educated. I hope it piqued your intellectual curiosity and you want to learn more. You want to learn more about Todd, you want to learn more about me, more about this subject, whatever. I'm just hoping that every day that I do a video, no matter how small, insignificant, that it just opens up a little bit more of the vision that you should endeavor. I was talking to somebody earlier, and we were talking about education, and we're talking about the kids. And it's going to be us, the enlightened ones, that are able to. God, I went over the 2-hour mark. Oh well. I'll just edit it down. The children born from 2020 on, they're going to be all digital children. They're not going to understand the world that I grew up in. They're just not going to comprehend it. They're not going to understand that you used to have to put a quarter into a phone to make a phone call. That's just not going to compute. They're not going to know how to cook because they're going to have 3D printers by the time that they're of age where they should be learning how to cook for themselves, prepare meals. They're going to be able to order a robo-taxi, a Tesla taxi, or whatever to take them wherever they need to be. But it's up to us that realize that there's a generation we're going to have to skip to recreate heaven on earth with a community of like-minded people where we raise the children to be the enlightened ones, to repopulate this place called Earth. If that's not your goal, if that's not your vision, well, it's mine. And that's what I'm living for. I guess that's my thing. I guess that's my God's passion that he put in me to do that. So I'm doing my little part with what I can, trying to give you guys some information as much as possible. I cover a broad section of topics. So some of them you'll be interested in, some of them you won't, some of them you probably should pay attention to. There's a lot going on. We're going into a digital realm. The all-seeing eye, capital I, AI, is the new world order, and don't think it's not. So it's all coming. You see what they're doing. They're already banning what? Islam in America. So freedom of religion, that's going away, folks. There's going to be one religion. There's going to be one currency. It's going to be one government. And we damn sure are not going to be in control. So come along on this journey with me, with this passion, this crazy life I live through my divine creator. God bless you all. Good night.